Honourable Minister of National Revenue.
Thank you, Mr. Speaker. I'm very pleased to have the opportunity today to speak to S7, the Zero Tolerance for Barbaric Cultural Practices Act, regarding Canada's commitment to preventing and responding to early and forced marriage, polygamy, or other types of barbaric cultural practices both at home and abroad. Our government does not shy away from tough conversations about the importance of women's full and equal participation in all aspects of social, economic, and political life. The promotion and protection of women's human rights are central to Canada's domestic, foreign, and international policy. And I'm proud to say that our government has made ending child, early and forced marriage a domestic and international policy priority. For example, in October 2013, our government announced $5 million in new money to address the causes and consequences of early and forced marriage around the world. These funds were used for programs in Afghanistan, Ethiopia, Ghana, Somalia, and Zimbabwe. More recently, in July 2014, the Minister of Foreign Affairs announced that Canada is contributing $20 million over 2 years to UNICEF toward ending child, early, and forced marriage. The UNICEF project aims to accelerate the movement to end child marriage in Bangladesh, Burkina Faso, Ethiopia, Ghana, Yemen, and Zambia by supporting efforts in these countries to strengthen both programming and political support to end the practice. Our government's commitment is not limited to funding. For instance, Canada has spearheaded the initiative to establish the International Day of the Girl and co-leading with Zambia a United Nations General Assembly resolution on child, early, and forced marriage. Additionally, Canada leads the annual resolution on violence against women at the Human Rights Council, as we are a strong supporter of the 6 UN Security Council resolutions on women, peace, and security. All of this goes to say that our government continues to work domestically and internationally on promoting and protecting the rights of all women and children. Equality of men and women under the law is a fundamental Canadian value that shapes Canadian policy and actions both in the international and domestic arenas. Free and healthy societies require the full participation of women. Sadly, in many countries around the world, millions of women and girls continue to be prevented from full participation by violence and intimidation, including through the inhumane practices of early and forced marriage. The strength of our country is centered on the fact that Canadians of very different origins live and work together, side by side. One of the key elements to this success, prosperity, and social harmony of our country is that we are united Canadian citizens, not by our common origins, but rather by a pledge of mutual responsibility and shared commitment to values and traditions rooted in our society. At the same time, harmful cultural practices which go against Canadian values and are in violation of Canada's international human rights commitments will never be tolerated in Canada. Our government is well aware of cases of Canadian children being taken abroad for an early or forced marriage, and has concerns that girls who are from countries where the practice of female genital mutilation is common may be at risk. Canada is committed to protecting and defending those who are vulnerable to these practices, both domestically and internationally. Our government has demonstrated its leadership in this area by introducing this bill and also by continuing to work with our international partners and community members to find ways to end such harmful practices which are tragically occurring each and every day around the world. I would like to speak now about how Bill S7 will protect women and girls here in Canada. The provisions in Bill S7 would strengthen Canadian marriage laws by establishing a new national minimum age for marriage at 16 years, as well as codifying both the existing legal requirements for a free and enlightened consent for marriage. Setting the minimum age to marry across Canada at 16 is consistent with current practices in like-minded countries such as the United Kingdom, Australia, and New Zealand. Provincial and territorial legislation will still impose requirements for marriages between the ages of 16 to 18 or 19, depending on the age of majority. Requirements such as parental consent or a court order provide added safeguards to permit mature minors between the ages of 16 and 18 to marry in exceptional circumstances. However, given that many forced marriages are perpetrated by parents, parental consent to the marriage of a minor may be insufficient to protect against forced marriage, where it is the parents who are forcing the marriage upon an unwilling child. As a result, the Minister of Justice has engaged his provincial and territorial counterparts in a discussion to enhance provincial and territorial legislative measures that would protect young children against forced marriage by imposing judicial consent in any marriages involving a minor. Bill S7 also proposes to amend the criminal code to create the offences of knowingly celebrating, aiding, or actively participating in a marriage ceremony involving a person under the age of 16 or a forced marriage. These new offences specifically address the social harm caused by the public endorsement of an unwanted or harmful legal bond within which sexual violence is expected to occur. These offences will apply to individuals who engage in conduct specifically intended to facilitate the marriage ceremony, such as acting as a legal witness, knowing that one of the parties is under the age of 16, or marrying against their will. These proposed new offences would be punishable by a maximum of 5 years imprisonment. The proposed amendments will also criminalize taking steps to remove a child from Canada for the purpose of an underage or forced marriage. This is done by adding the new offences in relation to underage and forced marriage to the existing offence of removing a child from Canada to commit female genital mutilation or sexual offences. This offence is punishable by a maximum of 5 years imprisonment, and Bill S7 maintains this penalty. Countries such as Australia and Norway have similar criminal measures, which Canada has looked to in the development of this bill. Other proposed amendments would create a new peace bond that would give courts the power to impose conditions on an individual where there are reasonable grounds to fear that a forced marriage or marriage under the age of 16 would otherwise occur, or if they will take a child out of Canada with the intent that they be subjected to an earlier forced marriage ceremony abroad. Such a peace bond would be used to prevent an underage or forced marriage by requiring an individual to surrender travel documents. These marriages that would prevent someone from being taken abroad for the purposes of earlier forced marriage are similar to forced marriage civil protection orders in the United Kingdom. Additionally, the bill proposes to amend the criminal code to address concerns that the defence of provocation has been raised in several so-called honour killings in cases here in Canada. Unfortunately, we have seen these cases too often on our soil, and one victim is one victim too many. The defence of provocation currently allows a person found to have committed murder, which carries a mandatory sentence of life, to seek a conviction of manslaughter instead with no minimum sentence unless a firearm is used, by arguing that the victim's conduct provoked them to lose self-control and kill. Currently, any conduct by the victim, including insults and other forms of offensive behavior that are lawful, can potentially qualify as provocation if it is found to be sufficient to cause an ordinary person to lose self-control, the accused was not expecting it, and the killing was sudden. The proposed amendment limit the defence of provocation so that lawful conduct by the victim that might be perceived by the accused as an insult or offend that person or their sense of family honor or reputation cannot excuse murder. Only conduct by the victim that amounts to a relatively serious criminal offence, that is, an offence under the criminal code punishable by at least 5 years in prison, could be argued to be provocation for the purposes of the defence. The provocation defence has either been abolished or restricted in almost every common law jurisdiction like Canada, most Australian states, New Zealand, and the United Kingdom. Finally, this bill proposes amendments to the Immigration and Refugee Protection Act to increase the Government of Canada's ability to prevent polygamy from occurring in Canada. This bill would make amendments to the RPA so that a polygamous permanent resident or foreign national who is or will be physically present in Canada with any of their spouses would be considered to be practicing polygamy in Canada. Mr. Speaker, I have discussed some of the very important aspects of this bill to highlight that Canada is taking concrete action in ensuring that early and forced marriage and similar barbaric cultural practices never occur in Canada, as was promised in the October 2013 throne speech. This bill also sends a strong message that Canada condemns such practices, not only domestically but internationally. I hope that the government will get the support, Mr. Speaker, of all honourable members in protecting victims, specifically women and girls.